Hi everyone, my name is Richard, and I'm the group leader for S1 Group 18 for the subject of Business and Corporations Law. Today our group presentation will be about the topic of ASIC versus SINL, which is the legal case that we have already chosen. Today's group presentation will cover the following areas. Well, first of all, my group member, Kristen, will give us a somewhat detailed case introduction. So in the case introduction, the parties involved, the plaintiff's purpose for litigation, and then the application for court decisions, and then the court verdict will be explained. And then the second part of the group presentation will be the duties and responsibilities that are breached by the defendants. Under these title, some of the court's orders will be detailedly explained. And the last part of the presentation will be mainly just about the implications of the court's decision making and a very brief conclusion.
Here I'm going to talk about the case introduction. Involving the court case of Australian Securities and Investments Commission versus Sino-Australian Oil and Gas Limited, abbreviated as ASIC versus Sino, or ASIC, the plaintiff, and the first defendant, Sino, followed by second and third defendants, Mr. Shaw, the former executive director and chairman of Sino, and Mr. He respectively, in addition to whom there are 7 other defendants. The purpose of ASIC bringing to court the defendants is to seek an order by the court to make the first defendant pay pecuniary penalty, and also to obtain a court order, which will occasion the disqualification of Mr. Shaw, the second defendant, from any corporate managing roles for a duration of 20 years. Essential to the court decisions is the direction sought on behalf of Sino from the court by Mr. Peter McCluskey, the liquidator of the first defendant. That direction application is made. The court has been satisfied that after evidence presented by both the plaintiff and the defendant has all been taken into consideration, and reference has been made to precedents similar to the present court case. Application for pecuniary penalty, and for compensation and for disqualification of Mr. Shaw from managing corporations for 20 years, and for direction to pass the liquidator's claim have both been granted.
Now in this part, I'm going to give actually a very brief description of the breaches and duties and responsibilities that were done by Mr. Shao and other defendants. So the court made the following declaration in relation to the breaches. The first declaration is that Sino transgressed the above acts of the Corporations Act, and for Mr. Shao specifically, Mr. Shao breached S6742A, and also in total Mr. Shao had 9 classes of contraventions of S1A01 of the Corporations Act. And those 9 classes of contraventions were actually used as the firm basis for ASIC and the court to establish the case for the compensation order for Mr. Shao to pay a certain amount of compensation to the first defendant, and for the disqualification of Mr. Shao from managing corporations for a duration of 20 years. And in addition to the above declarations, the court has also made the following discovery. So Mr. Shao obviously failed to take any reasonable measures to prevent Sino from contravening the act pursuant to S206E, and as an exacerbating factor, Mr. Shao, even though having realized that his misconducts had led to the unoperation of Sinol, he still chose not to take any reasonable measures to remedy the losses and damages suffered by Sinol. Now, in this part, the hefty pecuniary penalty will be explained in detail. So the evidence that the court relied on in order to reach that particular verdict is, first of all, Sinol was proved by ASIC to have failed to comply with the continuous disclosure requirements according to the Australian Corporations Acts. And that is, Sinol failed to disclose the emerging or the new set of circumstances that have already arisen before their release of the prospectus, and that behavior of withholding any important information to the potential investors was actually deemed illegal. And as such breach was also deemed very serious, given that the court was satisfied that such breach constituted market distortion and inaccurate information provision. The market distortion and inaccurate information as a result of the misconduct actually led to the losses and damages suffered by the investors of Sinol. And even though the court was aware that the market distortion and inaccurate information would not amount to such a heavy pecuniary penalty, the court yet still applied the reasonable inference principle. So the inference of the court was that the shareholders would have avoided such substantial losses had Sinol provided accurate information in a timely manner, which was before they released the shares prospectus. And as the court has clearly specified that the court is going to make the present case an example of serving a specific and general deterrence to any other foreign business entities that wish to seek Australian IPO and Australian listing. Now, concerning the disqualification order, the court actually discovered that and was satisfied that Mr. Shao breached the civil penalty provision under the Corporations Act, and ASIC even classified Mr. Shao's misconducts and breaches of his responsibilities and duties into the following 9 groups. Well, the 9 groups will not be detailedly explained here, but some examples are available. The first example is that Mr. Shao gave approval without understanding the English version of the IPO prospectus, and he still chose to assign it and then release it to the public for the raising of capital. And Mr. Shao also demonstrated his failure to understand the disclosure requirements in Australia, and Mr. Shao even transferred proceeds from operations in the Australian market without any proper documentation processes. And Mr. Shao even excused himself from his responsibilities and liabilities by asserting that his inability to understand the English language and the disclosure requirements were some sort of mitigating factors. And from what was said above, Mr. Shao has obviously demonstrated a loss of due diligence and due care and non-compliance with fiduciary obligations to Sinol. Now, in this part, we're going to talk about the compensation order. So the compensation order is applied for by the ASIC to the court, asking the second defendant to pay a certain amount of the compensation to the first defendant. So the first defendant is Sanol, and the second defendant is Mr. Xiao. Based on the fact that Sanol actually suffered substantial losses and damages due to the contraventions of Mr. Xiao, and the court also, and in addition to that, the court also applied the but-for test. So during the under the application of the but-for test, the court inferred that had not Sanol and Mr. Xiao failed in their due diligence to provide any accurate information to the general public, then the investors would not have suffered the damages and losses. And even there was testimony from other two non-executive directors who clearly stated that Mr. Xiao didn't understand the English version of the IPO prospectus, and yet he still chose to sign it and then release it. That is why the court agreed to the compensation order application of ASIC. Now, the last part is about the implications and conclusions. The implications of the court's verdicts are actually very common in the references of the group report. Well, in fact, the present legal case is actually a very huge example by a lot of law firms who advise any potential foreign business entities who wish to have their IPO succeeded in the Australian market. The first implication is that this present case serves as a deterrence to any foreign entity seeking Australian market share and then IPO. And the second lesson is that it is very necessary for the directors of the foreign entities to know the rules, play by the rules, and then abide by the laws. Well, the laws are basically the Corporations Act. And then in particular for those directors of foreign entities that are usually from an Asia-Pacific background, that before they sign or distribute any documents for capital raising purpose or any other purposes related to their operations, they should secure the appropriate law translations of the English documents. And that is the failure to do so will be an example of the absence of due diligence. And the last lesson is that directors and companies are actually in a fiduciary relationship, and directors should fulfill their due diligence and due care and fulfill their fiduciary obligations to the companies that they serve. So this is very much the end of the presentation. Thank you very much for your attention.